Kiev has no moral authority allowing it to put forward such accusations. That regime came to power following a violent coup d'etat in 2014. They arrived on the shoulders of nationalists, the direct descendants of Nazi collaborators from the Second World War. The current Ukrainian government openly acclaims and celebrates Nazi war criminals as Ukrainian heroes. The neo-Nazi groups on whose shoulders the current Kiev regime rests began by encouraging the armed revolts in western Ukraine. And this was well before the events that occurred in the east. They continued with the violence at the Maidan in Kiev, the effect of which was to overturn both the president and the legitimate government of Ukraine. As a result, a new government of victors, in inverted commas, including neo-Nazis, leaders of the Maidan, and their collaborators in key positions in charge of the armed forces, the police, and propaganda, came to power. They continued to spread terror throughout the entire country, killing opposition leaders, politicians, journalists, and ordinary citizens who quite simply dared to express their disagreement. Anyone who opposed, mainly in the eastern regions, in the Donbass, the answer given to these was a massive armed attack by the regime, and at the same time that same regime qualified them as terrorists in order to justify such brutal repression. For a period of 7 years, since the spring of 2014, that regime has decimated Donbass. Shelling, bombing, and daily killings have caused thousands of deaths and thousands of civilians injured, many of whom were children. The soldiers from Kiev and the neo-Nazi battalions have used civilians as human shields in order to protect themselves against the reprisals of the Donbass forces. What Ukraine is now seeking is a decision by your court that would allow it to treat the citizens of Donbass who are fighting for survival as, in inverted commas, equal to terrorists. But it is clear, it is generally acknowledged that the situation in Donbass was a bloody armed conflict between the Kiev regime and the Donetsk and Luhansk republics. A conflict governed by humanitarian law. Aside from Ukraine, nobody has ever considered that these republics were terrorist organizations. Madam President, distinguished members of the court, at the provisional measures stage, the court found that the arguments of Ukraine concerning the financing of terrorism were not plausible, given that Ukraine failed to demonstrate that the acts that it was referring to could even be considered as offences within the meaning of Article 2 of the ICSFT. At the judicial stage and at the stage of admissibility, the court decided to postpone its examination of the main arguments of Russia as to the merits, in particular those concerning intention and knowledge. Today, we are going to show you how Ukraine's claims are not just implausible. What is more, they are based on flawed interpretations of law and contradict even elementary common sense, and they are based either on fake factual evidence or contradict Ukraine's own position. The same can be said of Ukraine's allegations concerning a so-called systemic campaign of racial discrimination, I quote, against the Ukrainians and Tatars of Crimea. Ukraine has committed violations of Crimeans' rights, and this has been recorded over a period of years, nonetheless sets itself up as their protector today. It is all the more hypocritical because Kiev, together with the Mejlis, has established a blockade of Crimea, cutting off the peninsula from access to water, food, electricity, medication and other essentials to the detriment of the population. What is more, the members of the Mejlis set off bombs in order to destroy the energy lines leading to Crimea, thus depriving the entire population of Crimea of electricity. Ukraine is now looking for flaws in the educational system of Crimea, while approving the ban not only on education in the Russian language beyond elementary school, but also use of the Russian language in the media and in public life, notwithstanding the fact that the Russian language in Ukraine, contrary to the Ukrainian language in Crimea, is a language in daily use for the majority of the population. The actions taken by the regime in Kiev, contrary to the legal effervescence of its council, show that our opponents have no real interest in the well-being of Crimeans, nor for the struggle against their so-called, and I quote, discrimination. Kiev's real objective is not to fight against discrimination, but to challenge the status of Crimea, which is not at issue in this case, as the court itself affirmed in its judgment of 2019. Ukraine shows similar bad faith in the case of Donbass. There too it was not interested in a peaceful solution. The Minsk agreements were based on the idea of a return of Donbass under the control of Ukraine, while respecting the desire of the Donbass population to enjoy broader autonomy. It transpires today, according to the former Ukrainian, French and German leaders who signed or guaranteed these Minsk agreements, that their only real purpose was to give Ukraine time to arm itself for a military solution to the Donbass question. Unfortunately, Kiev never intended to respect these agreements. Its only objective was to conquer Donbass by force. Kiev's actions ultimately pushed the Donetsk and Lugansk People's Republics into invoking their right to self-determination and legitimate defense, including collective legitimate defense, in accordance with the provisions of the United Nations Charter and international customary law. Of course, this case does not concern the most recent events. In fact, it only concerns the events that occurred between 2014 and 2017. Nonetheless, as Ukraine's agent has focused so much on this aspect, I will say that it is Ukraine which rejected the Minsk agreements and began the violence against Donbass. It is Ukraine which refused any negotiated solution and announced its desire, and I quote, to win on the battlefield. End of quotation. It is the Ukrainian senior officials who called people to, and I quote, kill all Russians, kill them everywhere. End of quotation. They began by killing journalists and political activists, not just in Ukraine, but also in Russia. Ukraine is constantly turning to propaganda, blatant lies, and false accusations leveled against the Russian Federation. Even before this court, on the first day of the hearing, Ukraine's agent stated, and I quote, "Today, Russia was behind the destruction of a large dam at Nova Kakhovka." End of quotation. In fact, this was done by Ukraine. The Kiev regime not only launched massive artillery attacks against the dam in the night of the 6th of June, but it also deliberately forced the water level of the Kakhovka reservoir to a critical level by opening the valves of the Dniprovsky hydroelectric plant. Of course, we all know full well who it was who pushed Ukraine along the path of destruction by transforming it into a cauldron of violence, and who it is who supports it also as a proxy in the pursuit of a legal warfare, between inverted commas, against Russia within this very same court. We appear before you today in order to demonstrate that Ukraine's application must be dismissed, because it is without any legal foundation, nor does it have any factual evidence to back it. In fact, neither the ICSFT nor the CERD bear any relation to the subject of the current disagreements between the two countries. They are simply being used by Ukraine, and I quote, as a means of bringing a broader set of issues before the court. The artificial nature of this case is also demonstrated by the fact that it includes two factual situations that are totally different, and in fact two totally separate cases. And that is why, as usual, we have organized today's oral arguments in two parts. Mr. Kuzmin will set out our objections concerning the ICSFT. Our counsel will then go into more detailed arguments, after which Madam Zabolotskaya will address the CERD, and other counsel for Russia will go into the legal and factual arguments. I would now like to ask that you give the floor to Mr. Kuzmin.
I thank the agent of the Russian Federation, and I now give the floor to His Excellency Mr. Gennady Kuzmin, agent of the Russian Federation. You have the floor, Excellency.
Madam President, members of the court, it is a privilege to appear before you in order to introduce the Russian Federation's case on the ICSFT. Ukraine's agent said on Tuesday that Russia is here to pay tribute to international law. It's true. Russia respects international law in the court as a principal judicial body of the United Nations. But does Ukraine respect the court? Apparently not. Otherwise, Ukraine wouldn't bring to this court such allegations which have no basis in law or fact. On Tuesday, Counsel for Ukraine, Mr. Kor, said something about a big lie. There are certainly big lies involved. But they come from the Ukrainian side, which continuously attempts to deceive this court with false and or incomplete information, even omitting or distorting its own evidences when it clearly contradicts Ukraine's claims. Perhaps the biggest lie coming from Ukraine is that people fighting for survival are terrorists. After the extremely violent coup d'etat and the attempt to kill the legitimate president of Ukraine, who was forced to flee the country, the Maidan regime unleashed the brutal crackdown on all dissenters, culminating in the horrible massacre in Odessa on 2nd May 2014, when over 50 people were burned alive by Maidan regime. That was not considered an act of terrorism and has not been effectively investigated to this day. The east of Ukraine rejected this hostile regime. Kiev responded by launching an armed attack against its own citizens, labeling it an anti-terrorist operation. The attitude of the Maidan regime towards Donbass may be summarized by one quote from Deputy Prime Minister Reznikov. He called Donbass a mentally ill territory and the cancerous tumor that must be cut out. Mr. Kor asked, who targeted the civilian population? The response was very simple. It was Ukraine that conducted most of the shelling in the Donbass conflict. This is confirmed by the very reports of the UN and the other bodies that Ukraine relies on. The majority of civilian victims are on the side controlled by the Donbass Republic, shelled and bombed by Ukrainian armed forces. Please see timeline of Ukrainian attacks. In doing so, Ukraine used the very same Grad and Smerch multiple launch rocket system. It claims are inherently indiscriminate weapons. Russia provided an extensive, although by no means exhaustive, list of such incidents in our rejoinder. When talking about shelling, Ukraine ignores the vast amount of evidence, including from its own side. For instance, with regard to Mariupol, Ukraine never mentions the interrogation of Kirsanov, who allegedly acted as a spotter for DPR, but deliberately supplied wrong coordinates of military objectives in the city. This is confirmed by materials presented by Ukraine in this court, as well as by the decisions of Ukraine's own courts and publications of Ukrainian media. Ukraine also constantly downplays the fact that it routinely located its armed forces in residential areas in order to use them as human shields. In the case of Kramatorsk, Ukraine concedes the presence of high-value military target, and Ukraine's own expert agrees that the Smerch multiple launch rocket systems was an, I quote, ideal tool for the job. The question only being the range of deviation of some of the rockets. Considering Ukraine itself routinely used Smerch to attack cities with many civilian casualties and never considered it terrorism, at least this is a moot point. In Volnovakha, Ukraine absurdly claims the Bugas checkpoint is not a military object. even though its own legislation clearly says otherwise, as does the presence of military personnel, armored vehicles, artillery, fortifications, and minefields. Ukraine also completely ignores the evidence that shows how the attack could have been friendly fire or deliberate provocation from the Ukrainian side. Mr. Kaur also asked, who did the United Nations human rights monitors find was responsible for a reign of intimidation and terror? In fact, the very reports that Ukraine cites clearly state that it was Ukraine's so-called anti-terrorist operation that was largely the cause of, I quote, a climate of insecurity and fear in Donbass. The UN monitors say that the civilians were caught in the crossfire between Kyiv government forces and the rebels. That accusations of financing of terrorism against those supporting the eastern regions are hate speech and should not be used as a pretext for persecution. That the Ukrainian security service was engaged in illegal arrests and forced disappearances of those who opposed Maidan regime. And that the assisting, I quote, communities in the East is a new civic spirit that will help drive the next phase of the much-needed change in Ukraine. Finally, the UN monitors urged all sides to lay down their arms and engage in a peace process, which Ukraine stubbornly refused to do for 8 years, despite concluding the Minsk agreements. Mr. Kaur also asked, who destroyed MH17? He seemed to think it is a rhetorical question, but it is not. What Ukraine failed to mention to this court was the presence and operation of numerous Ukrainian books in the Donbass zone on conflict on the day of the MH17 incident in the direct vicinity of the crash site. This is proven by the information from the Netherlands authorities supplied to the Hague District Court. Ukraine has failed to prove that the missile which allegedly shot down the airplane was of a new type. And Russia has proven that this missile, remains of which were allegedly discovered during the JIT investigation, belonged to Ukrainian armed forces. Ukraine attempts to downplay the fact that the Ukrainian armed forces have previously already shot down a civilian airliner, killing all 78 people on board, and nobody was accused of terrorism or even brought to justice for murder. While Ukraine's own president has said that mistakes happen, we are not the first and not the last. On Tuesday, Ukraine even had the audacity to claim it was a lawful act. Ukraine's evidence that the alleged book came from the Russian Federation is extremely flimsy and replete with fakes, as we will demonstrate today. On Tuesday, Ukraine had nothing to say on this matter and chose to ignore it completely. Ukraine has also failed to prove any kind of terrorist intent with regard to MH17. On the contrary, even the Hague District Court, which otherwise displayed obvious bias against the DPR and favored Ukraine, concluded that there has been no intent to shoot down a civilian aircraft, and that the book was procured and used for air defense purposes. The Hague Court, the Dutch prosecution, and the JIT agreed that there was no evidence of terrorism or of a war crime. Ukraine's arguments hinges on the book allegedly being an indiscriminate weapon. This is an absurd claim, even prima facie, since the book is, of course, a highly sophisticated, precision-guided weapon system designed to accurately destroy specific targets. Ukraine brazenly distorts expert reports, completely ignoring the fact that experts agree that the book dealer does have the capability to distinguish civil aircraft from military, and that the Tiller was originally designed to be capable of autonomous operation. Mr. Koch claimed that the book had been allegedly fired at civilian-trafficked skies. He wants you to turn a blind eye to the fact that these skies were filled with Ukraine's own combat aircrafts, constantly attacking DPR's position and bombing DPR cities, killing civilians, including women and children. Ukraine chose not to close the airspace over the zone of conflict to civilian traffic. This falls into the pattern of Ukraine actively using civilians as human shield to protect its own armed forces from rebel attacks. At the end of the day, Ukraine's MH17 case boils down to nonsense. That it is lawful and unintentional for soldiers to shoot down civilian aircraft by mistake during a peacetime, but unlawful, intentional, and a terrorist act to do so during a time of war, while believing the target to be an enemy military aircraft. This contradicts not only to the black letter of the relevant instruments, but also the interpretation of the competent international bodies, the views of legal scholars, and extensive state practice, all of which indicates that mistaken downing of a civilian aircraft in time of war negates intent for the purpose of terrorism or war crime. Ukraine's accusation of terrorism financing is all the more absurd as Ukraine itself continued to trade with DPRs and LPR in coal, steel, and even weapons. Mr. Koch said how Russia did nothing to cooperate with Ukraine. This is a plain false. Russia engaged at lengthy correspondence and consultations with Ukraine, which lasted for years. However, it was Ukraine which sabotaged its own cooperation requests by wording them in vague manner that did not allow for qualification under ICSFT, by rejection of Russia's request for additional information, and by refusing to provide a list of requests relating to terrorist financing. Ukraine did not even refer to ICSFT in its MLA requests. Since 2014, Russia received around 1,000 MLA requests from Ukraine and executed almost 800 of them. Of these, Ukraine selects only 12 as purportedly related to ICSFT as evidence of Russia doing nothing. Ukraine also claims that Russia should have trusted Ukraine in its claims that DPR and LPR are terrorist organizations, instead of asking for some objective evidence of that being the case. Today we will show that there was no basis for such trust at all, as Ukraine routinely used trumped-up charges of terrorism and its financing to persecute dissenters, and none of the incidents Ukraine brings to the court are actually acts of terrorism. Finally, Ukraine itself has on multiple occasions rejected Russia's request for legal assistance, including those regarding terrorism, on the grounds of sovereignty. In some cases, for instance concerning Hizb ut-Tahrir, Ukraine openly stated that it did not trust Russia's qualification of this organization as terrorist and thus would not execute the request. The presentation of Russia's case on ICSFT will take place in the following order. Mr. Michael Swainston will present Russia's position on intent and knowledge as requirements for the offense of terrorism financing under ICSFT. Professor Khariazari will show how funds under ICSFT do not include weapons. Professor Singhoi will clarify the interplay between ICSFT and international humanitarian law in time of armed conflict. Mr. Swainston will return to show how Ukraine's allegations concerning MH17 have no basis in law and fact. Mr. Kirill Udlichenko will demonstrate the same with regard to allegations of shelling, bombing, and killing. Mr. E will return after the lunch break to show that Russia fully complied with its obligation in cooperation under ICSFT. And I thank you for your kind attention and request you, Madam President, to give the floor to Mr. Michael Swainston.
I thank the agent of the Russian Federation, and I now invite Mr. Michael Swainston to address the floor. You have the floor, sir.
Madam President, distinguished members of the Court, it is an honour to present to you today part of Russia's answer to Ukraine's case under the International Convention for the Suppression of the Financing of Terrorism. Ukraine accuses Russia of the serious offence of terrorist financing, and it's trite law that with a serious offence the accuser must have a clear case in terms of the elements of the offence in law, and the evidence must be compelling. Ukraine's case therefore starts on unpromising ground, because generally we will see that terrorism offences require a specific intent, such as to injure civilians for a political purpose. By contrast, Ukraine relies on a mistake of targeting in relation to MH17, and Ukraine relies on alleged shellings and bombings in the course of an armed conflict. But injury in armed conflict to civilians is inevitable. It does not point to terrorism. Sadly, it happens even where scrupulous efforts are made to follow international humanitarian law, which regulates conflict. Professor Jen Zolin has pointed out the importance of that distinction between combatants and terrorists. What is at stake is nothing less than the distinction between the two. It is imperative to distinguish between terrorists who deliberately target civilians and soldiers who foresee that civilians will be killed as collateral damage while striking a military target. The former is a war crime, while the latter represents lawful conduct. And, of course, soldiers also make mistakes. So a key issue in these proceedings is the mens rea required for the terrorist funding offence under Article 2.1 of the ICSFT. The starting point is what the treaties say, and here the ordinary meaning of the words in context and having regard to the object and purpose of the treaty. That's our slide 4. When we look at Article 2.1 of the ICSFT, it is entirely clear that it creates an offence requiring specific intention of the funder to fund terrorist crimes under Article 2.1a, or terrorist acts under the catch-all provision in Article 2.1b. Ukraine has cited former Ambassador Margelato, but please see our next slide, slide 5. On mens rea, Ms. Leto agrees that intention is carefully set out and that specific intent on the part of the funder is required. I quote, "The perpetrator must have a specific intent that the funds will be used to commit crimes, or he or she must at least know that the funds are to be so used. The construction of the crime is not self-sufficient, but relies on other instruments. We shall soon see that those other instruments also require specific intent on the part of the terrorists who are funded." As regards the funder, the key word is willfully, slide 6. Professor Aust has explained that willfully was used to emphasise the requirement of specific intent in relation to funding. It doubles up on the subsequent express requirements of intention or knowledge in Article 2.1. And it's convenient to look at those requirements in Article 2.1b, the catch-all provision for terrorist acts, because that doesn't depend on the separate treaties listed in the annex. Article 2.1b sets out requirements of specific intent at two levels, the funder and the funded terrorists. The funder must provide funds unlawfully and willfully, with the intention or knowledge that the people funded will carry out an act intended to injure a civilian or non-combatant. And the funder must also know that this is their intent and that the terrorists have a special purpose of intimidating a population or influencing a government or international organization. Please note that all of this is specific, direct, subject intention. The only concession to objectivity is the point that special political purpose can be derived from the nature or context of the planned act. In Ukraine's opening submissions, there was an error on this point. My learned friends focused on special political purpose and the objective element there, but then they proceeded as if it applied to all of the mental elements in Article 2.1. And with respect, that is obviously wrong. Political purpose is the only mental criterion where there is a concession to objectivity on the basis of nature of the act and context. The rest requires specific intent on the part of the funder and on the part of the terrorist. There is significance in the fact that political purpose was singled out for an objective test based on the nature and context of the act. It shows that when the state parties wanted to move away from subjective intention, they did so expressly. Article 2.3 is very informative and important on the essential aspect of intent. See slide 10. It's critical to note that the entire offence of terrorist financing is complete when the financing is provided. There is no need for a terrorist offence or terrorist act to be completed, and indeed there may be none. On the contrary, the offence of funding terrorism is made out precisely because the funder intends or knows that the terrorists will carry out a terrorist act with terrorist intent. In relation to the whole of Article 2.1, A and B, Ukraine says it would be odd if mens rea of the funder requires the funder to know the mental state of third parties, in other words, the funded terrorists. But with respect, that is not odd at all. The whole offence is complete at the point of financing. It depends on the funder's knowledge of the terrorist's terrorist intent. It is exactly that knowledge that makes the funding dangerous. So Article 2.1b requires clear, specific intention at the level of the funder and at the level of the terrorist. The same applies in relation to the funding of terrorist offences under Article 2.1a. Article 2.1a says the funder must intend or know that one of the crimes in the listed treaties in the annex is going to be committed. This is a requirement for specific direct intent on the part of the funder, and the funder must know the criminal intent of the terrorists. Otherwise, clearly, the funder does not know that a terrorist offence will be committed, because all of the relevant terrorist offences require specific criminal intent on the part of the terrorists. Let's start with the Montreal Convention. Slide 12. The offence catches a person who unlawfully and intentionally destroys an aircraft in service. That raises the question, What kind of aircraft? The answer, from the plain words in context, is clear. First, the title of the convention is Convention for the Suppression of Unlawful Acts Against the Safety of Civil Aviation. The acts in question must be directed against civil aircraft. The same point flows from the preamble, which you have at slide 15. Considering that unlawful acts against the safety of civil aviation jeopardize the safety of persons and property. Again, this is unlawful acts directed at a civil aircraft. In their submissions, my learned friends for Ukraine said the intention to destroy any aircraft was enough. The word civil was not in the article, but it is in the convention, in the title, and in the preamble, and it is the entire context. Article 4.1 puts the matter beyond doubt. Slide 16. It provides this convention shall not apply to aircraft used in military, customs, or police services. We give the overall result of all this at slide 17. The convention creates an offence of specific intention, and the intention plainly relates to a civil aircraft. There must be a specific intention to destroy a civil aircraft. Now, in its reply, Ukraine says two things. First, the status of the destroyed aircraft dictates whether the convention applies. In other words, the type of aircraft is a jurisdictional point. We can wait and see whether the Montreal Convention applies, depending on what kind of aircraft is shot down. That's their first point. Second, they say that the status of the aircraft is not part of intent. But again, with respect, this is hopeless. We have seen that under Article 2.3, the offence under the ICSFT is complete at the point of financing. There need not be any actual attack. It's therefore impossible to wait for a tragedy to happen with mistaken targeting and then retrospectively to decide that the ICSFT applies because retrospectively the shooting down was within the Montreal Convention. Ukraine proceeds to cite irrelevant authority for the notion that the mens rea requirements in Article 2.1 are only jurisdictional. Ukraine cites the Tadic case, a decision of the International Tribunal for the former Yugoslavia. But that tribunal was dealing with Article 5 of that tribunal's founding statute, which says the International Tribunal shall have the power to prosecute persons responsible for the following crimes when committed in armed conflict, and various crimes are then listed. But that is absolutely not our case. The founding statute did not create offences. It set out the jurisdiction of the tribunal with respect to certain offences. Here, the ICSFT was creating the offence of terrorist financing. It did create that offence, and it did so with clear express requirements of specific intent at the level of the funder and at the level of the funded terrorists. Moreover, it's clear in context that this specific intention covers the civilian status of the aircraft. We've seen that with the title, the preamble, and Article 4. The ILC endorses that view at the highest level of international legal analysis and commentary. See slide 19. We've cited the commentary on the 1972 draft articles on the prevention and punishment of crimes against diplomatic agents and other internationally protected persons. And the commentary says the word intentional, which is similar to the requirement found in Article 1 of the Montreal Convention, has been used to make clear that the offender must be aware of the status as an internationally protected person enjoyed by the victim. So the ILC thought that under the Montreal Convention, intention takes in the status of the aircraft. There must be an intention to destroy a civil aircraft. The ICSFT does not cover mistakes. The point on mistakes also appears from the travaux. You see it, paragraph 5.1 on the next slide. It refers to, in some cases, such an act would be inherently destructive or harmful and intentionally done, and not through inadvertence or mere negligence, would constitute an offence. This interpretation is also supported by the teachings of leading jurists, which you can see on slide 22. For example, Professor Trapp, the Montreal Convention requires states to prevent the unlawful and intentional destruction of a civil aircraft in service. Slide 22. No one was suggesting that mistakes in targeting should be treated as terrorism. And there's a broader point. No one suggests that military activities in the course of armed conflict should be treated as terrorism. On the contrary, Russia's drawn attention to widespread consensus that the old terrorism conventions like the ICSFT do not cover acts in armed conflict. And you see that at slide 22. And as set out in slide 23, we have ICAO comment. In the ICAO, it's been widely understood that the aviation security interests that criminalise certain acts are not applicable to the military activities they mention above. According to the ICAO, that exclusion can be made clear by amendment in later terrorism conventions, but when it happens, such a clause would be considered as declaratory in nature. The reason being there is already an implied military exclusion. And that appears clearly as well from the Beijing Convention designed to replace the Montreal Convention. See slide 24. At Article 5.1, we've got an express military exclusion like that in the Montreal Convention at Article 4. We also have the ICAO consolidating amendment at Article 6.2. And it says the activities of armed forces during an armed conflict, as those terms are understood under international humanitarian law, which are governed by that law, are not governed by this convention. And the activities undertaken by military forces of a state in the exercise of official duties, inasmuch as they're governed by other rules of international law, are not governed by this convention. And the same point arises on the Beijing Protocol. Madam President, distinguished judges, all of this reflects international consensus that bad targeting, especially in the course of armed conflict, is not terrorism. One only has to look at the sadly growing list of instances where passenger planes are shot down by mistake to see that, including, as we've heard, by Ukraine. None of these instances, none, has been regarded as terrorism by the international community. And in the USS Vincennes case, which reached this court, the United States made very clear its view that the convention did not catch military activities. We've set out their submissions at slides 27 and 28. All the indications are that this view of military exclusion is generally held. On Tuesday, Ukraine tried to avoid the problem of past examples of mistaken shooting by saying that in all of these cases the shooting was lawful, whereas anything done by the DPR was not. Ukraine relies upon the judgment of the Hague Court to say that DPR members did not have combatant immunity under IHL. But with respect, the Hague judgment is very strange on that point, because the Hague Court found that the conflict in East Ukraine was an international armed conflict, and there IHL plainly gives combatant immunity. And with respect, one must consider the absurdity of Ukraine's position. It comes to this: when a state destroys an aircraft in peacetime by mistake, that is not terrorism under the Montreal Convention. But when a combatant does so, in the heat and pressure of battle, it becomes terrorism. With respect, that makes no sense at all. Ukraine places bad reliance on the decision of the Hague Court on the analogy of murder. They point out that the court considers that if A intends to murder B and murders C by mistake, that's no defense, it's still murder. But there is no analogy with our case. In domestic law, A cannot kill B or C. The position is different here, under the ICSFT, where there is an armed conflict. First, there is no terrorist intent when somebody fighting in an armed conflict makes a mistake. There's no terrorist intent when the mistake is made in peacetime or in conflict. And secondly, there is a general exclusion of military activities. So that is the Montreal Convention. We need to look quickly at the ICSTB, the Terrorist Bombing Convention. Ukraine ignores the requirements for specific intention there. Again, a person commits an offence within the meaning of the convention if that person unlawfully and intentionally delivers an explosive, etc., in a public place, etc., with the intent to cause death or serious bodily injury, or with the intent to cause extensive destruction. It's clear from context, injury and damage relate to civilians and civilian infrastructure. And Ukraine also ignores the exclusion of military acts in this convention from the scope of terrorist bombing. It's only concerned with terrorism. We see the references in the title and preamble, and there's an express exclusion of military activities in Article 19.2. The activities of armed forces during armed conflict, as those terms are understood under IHL, are not governed by this convention. So both of the relevant treaties listed in the annex creating predicate offences for terrorist financing require terrorist intent, and they exclude military activity. So how does Ukraine persist in its case? Well, first, it makes a general point to cloak its inability to deal with specific intention. It says that if specific intent is required at the level of the funder and the funded, the offence will be difficult to prove. They say that's inconsistent with a broad object and purpose of suppressing terrorism. But with respect, that's not constructive. It assumes the conclusion. The offences created under the ICSFT and the listed conventions are very serious. It's entirely appropriate that they should depend on proof of serious criminal intent. And next, Ukraine says, well, intention is not defined, so it can introduce different degrees of intention. But that, with respect, is not right. As we've seen, Ambassador Leto observed, and it's plain for anyone to see, intention is carefully set out, and it's specific and it's direct. It's set a specific intent at the level of the funder and at the level of the funded terrorist. The only point left to objective assessment is special political purpose under Article 2.1b, which can be gleaned from nature or context of the Act. But that is a single instance, and it shows that when states wanted that, they used express words. And that position fits with what we have on slide 37. Other words, other definitions of intent were considered. The United Kingdom said it should be sufficient if a person provides funds in circumstances where there is reasonable suspicion that they will be used for terrorist purposes unless the person can prove otherwise. That was rejected. We should also pick up a comment from the United Nations Office on Drugs and Crime at slide 38. It addressed how to draft national law to reflect the ICSFT, and it made clear that specific intention or knowledge was required. So when national laws referred to reasonable cause to suspect, it points out at the end that there could be problems with requests for international assistance. Last 4 lines. Now, Ukraine says it does not rely on the first limb of Article 2.1, intention that funds are to be used for terrorist offences or terrorist acts, intention that they should be used. We see that at slide 39, Ukraine's reply at footnote 110. Instead, Ukraine relies on Russia's purported knowledge. But this purported knowledge, Madam President, members of the Court, turns out to be alleged knowledge of a risk, which Ukraine says is sufficient to found dolus eventualis. And that risk is said to come from two things. First, in relation to MH17, it comes from the suggestion that a buck TLAR is an indiscriminate weapon, creating a risk for civil aircraft. The second factor is said to be the notoriety of the DPR as a terrorist organisation from which terrorist acts could be expected. You've heard from Russia's agent that that is an absurd description of the DPR, but both points are unsustainable. Before we turn to them, we should note in parenthesis that Ukraine's case is confused at this point. Ukraine recognises that recklessness is not sufficient. See its reply, paragraph 109. Recklessness, in ordinary English, is the deliberate running of a risk. And then, when Ukraine tries to turn knowledge of risk into intent, it cites Italy against Abdelaziz, slide 42. That's relied upon for the example of an attack on a military vehicle in a market where civilians are present, and it's said by the court that there was a certainty of serious harm to civilians, and that is said to show that the act was motivated by terrorist intent. However, number one, this speaks of certainty, not risk. There is no analogy with Ukraine's case here. And secondly, there is no consideration of the exclusion of military activities in armed conflict. But anyway, the factual propositions for knowledge of risk don't stand up. First, we should note that Ukraine says that the buck was a Russian buck with a trained Russian crew. We have that and the references at slide 44. The intercepts relied on at slide 46. The observations of a journalist, slide 47. And the intercept confirming the arrival of a buck TLAR with a crew at slide 48. Please understand that Russia absolutely rejects all of this case. There was no Russian buck. No buck came from Russia. No crew for a buck came from Russia. And we will see later that the evidence propping up this case is unsourced digital nonsense. But nonetheless, for the purpose of legal argument, Ukraine says there was an experienced crew. And on Ukraine's own evidence, an experienced crew should be able to distinguish between an airliner and a military ground attack aircraft. See slide 50, setting out words of Ukraine's own expert, Dr. Skorik. An experienced Buck M1 TLAR commander and operator can fairly accurately identify the target based on its parameters, jet engines, dimensions, and so on. And the court can take judicial notice that the dimensions in this case are very, very different. Dr. Skorik makes clear that the Buck TLAR has an autonomous independent mode. Slides 53 and 54 cover that. It has its own radar. AR in TLAR means and radar for targeting. And Russia's own expert agrees that a trained crew can identify military targets, and they must do so as part of the procedure for firing. That's the evidence of Mr. Bezborodko at Annex 6 to Russia's rejoinder. He again describes how Buck TLARs have got their own radar. The TLAR can track the speed, altitude, and direction of a potential target and see its shape. The crew must assess the target type as part of the procedure for engaging a target. and a buck TLAR fires a guided missile at a specific target which has been identified as a military one. It absolutely follows that a buck TLAR is not an indiscriminate weapon, and analogies with nuclear weapons are precisely irrelevant. But there's another point on this. It's inconsistent with what Ukraine actually did. The agent for Russia introduced a document from Netherlands military intelligence which was asked whether MH17 was within range of a buck when it was destroyed. Incidentally, it said no, and we'll see that later. The document with English translation is at slides 57 to 61. The important point to note from the English translation is that Ukraine had buck TLAR units in theatre. And if we can see the table, they're exactly the same buck TLAR units as are attributed in the table at the bottom to Russia. This is covering the whole region. We can also see that these buck TLAR units were operating separately. And we know that because Dr. Skorik, Ukraine's expert, said a complete system includes a command unit, a targeting unit, and 6 buck TLARs. These are scattered and separate. We also know that Ukraine issued a NOTAM setting a level for civil aviation of 32,000 feet, when we know that bucks fly higher than that. How does that fit? What it shows is Ukraine knows full well that buck TLARs operating autonomously can discriminate. They are not indiscriminate weapons. But the crew of a buck is human. Humans make mistakes. As Mr. Bezborodko pointed out, it's wrong, and please do read his report, to say he said it was inevitable that civilian aircraft would be shot down. What he said was, mistakes happen. He also said they were unavoidable, and he said it in the context of the USS Vincennes, but talking about surface-to-air missiles as a whole. We've heard from the agent how the Dutch criminal court did not find any terrorist intent on the part of the DPR to shoot down aircraft, and even the JIT ruled out a war crime because of the absence of specific intent. Note the language, implausible. They did not intend to kill civilians. There was no basis for anticipating, even on Ukraine's fictional case, that a trained crew would make a mistake, just as in previous instances where mistakes were made. It's convenient to mention a point on provision in this context. On its fictional case, Ukraine says there was a Russian buck with a Russian crew. The buck TLAR belonged to the Russian army. It was under a Russian crew. It came from Russia. It returned to Russia. That's nonsense, but that's what Ukraine says. None of that involves provision of anything. The only thing sought to be provided was air cover against military attack. And air cover is definitely not funds, and it's definitely not any kind of asset. But I return to the second way that Ukraine says that funders in Russia had knowledge of a risk of terrorist attacks. Ukraine talks about the reputation of the DPR as a terrorist organization. But only Ukraine says that. No other state says it, no other international body says it. Ukraine relies on a report from the OHCHR to the effect that the DPR inflicted a reign of intimidation and terror to maintain their position of control. Now, there are lots of problems with that Russia has set out in writing, and please read them. But notably, the OHCHR was not dealing with terrorism under the ICSFT. It uses words terror often, including in relation to Ukraine and Ukraine's forces. And it does not say that the DPR was specifically targeting civilians with ground-to-air missiles or with shells or with bombs. On the contrary, it was careful to note that heavy shelling was coming from both sides, and it urged all sides to put down their arms and engage in dialogue. The OHCHR also did not criticize aid to the East. it welcomed the assisting of communities in the East. Now, the point on a trained Russian crew on Ukraine's fictional case extends to this aspect of supposed intention through knowledge of risk. Ukraine talks about the reputation of the DPR, but that's irrelevant if on Ukraine's case the buck Tila was in the hands of a trained Russian crew. Because whatever might be said about the reputation of the DPR, and all that has been said is completely unjustified, nobody could expect a trained Russian crew to make a mistake and shoot down the civilian airliner. But as we've seen, mistakes happen. So, on Ukraine's materials, Ukraine has totally failed to show an intention or knowledge of funding terrorism. There was nothing that amounts to intention or knowledge under the ICSFT Article 2.1, and there was nothing that qualified as a terrorist offence or terrorist act under Article 2.1a or 2.1b. But I would like to make a last point, which meshes with an observation of the Russian agent. I've talked a lot about the fact that terrorist conventions do not cover armed conflict and military activities. And we've seen the implied and express military exclusions. Armed conflict is governed by IHL, and that is outside the jurisdiction of this court, except that it can inform the interpretation of instruments that are before the court. The reason for that lack of jurisdiction, compulsory jurisdiction on IHL, is a practical one. States do not support compulsory jurisdiction over armed conflict because in time of armed conflict there's a huge risk of propaganda and there's a real likelihood that the true facts will be lost in propaganda or the fog of war. Anticipating my later submissions, there is a very great risk that that has happened here. Those are my submissions, Madam President. I would invite you to give the floor to Hadi Azari, who is going to deal with funds.
I thank Mr. Swainston, and I now give the floor to Professor Hadi Azari. You have the floor, Professor.
Merci beaucoup.
Thank you very much, Madam President. Madam President, distinguished members of the Court, it is a great honor for me to appear before the highest international jurisdiction to represent some of the aspects of the Russian Federation's response. A significant share of Ukraine's arguments, in particular concerning the tragic accident of flight MH17 and other alleged terrorist attacks, relies on the assumption of the term funds within the meaning of Article 1.1 of the ICSFT. And this has a very wide scope, which is in fact infinite. For Ukraine, the term funds covers, and I quote, everything under the sun, unquote. And I'm going to demonstrate that this argument is untenable, but I will not take too much time because the question doesn't require a lengthy discussion. The term funds in Article 1, Paragraph 1, that appears on the screen is limited to specific categories of financial assets that have an intrinsic monetary value. They constitute forms of payment and can be freely and legally purchased, traded, and sold. Ukraine proposes only a partial reading of this article. It invites us to read only the first line of the provision and simply ignores the rest of the provision. And this is not a good faith interpretation of Article 1 of the Convention. The notion of funds must be read in the context of the whole provision, and in particular in the light of specific categories of funds that are mentioned in it. In other words, bank loans, travelers' checks, bank checks, money orders, shares, securities, bonds, bank drafts, letters of credit, and documents or instruments attesting to ownership of assets or a right over these assets. All these examples refer exclusively to assets that have three common features. First of all, they have an intrinsic monetary value on their own. Secondly, they're forms of payment. And thirdly, they can be freely and legally purchased, traded and sold. Well, these are just examples, it is true, but they're all of the same kind. Is it insignificant? The answer is no. In law, nothing is insignificant, and good faith interpretation indicates clearly that the term funds is meant to encompass only instruments and financial securities, be they movable or immovable, whose nature is similar to those assets explicitly enumerated in Article 1, Paragraph 1 of the Convention. The purpose of the definition is to cover items meant to finance the perpetration of terrorist activities rather than the items that are themselves used to commit these very terrorist acts. The title of the Convention expressly refers to suppression of terrorist financing. Professor Coe told you that the title means nothing. He is wrong. The court considers the title of a treaty as well to determine its object and purpose, and this is abundantly illustrated. Just to give you one example, in your judgment on preliminary objections in the certain Iranian assets case, you said, and I will just read the relevant part that is underlined, the same applies to the object and purpose of the treaty as set out in the preamble, and an indication of which can also be found in the title of the treaty. The word financing or financier appears at least 14 times in the 1999 Convention. The word weapon appears 0 times. Ammunition appears nowhere. And terms that have a military connotation never appear. And yet, Ukraine is asking you to read them in Article 1 of the Convention. But can we seriously imagine that an issue as sensitive as the regulation of weapons supply to non-state terrorist groups would be treated, as Ukraine contends, so implicitly and be so casually included in a term that only has a financial and economic connotation? Madam President, distinguished members of the court, when states decided to focus on the transfer of weapons in the Convention, they did so in an explicit manner. There are several examples of this. In our case, they decided to restrict the scope of the application to financial support provided to terrorists. However, it is the basic principle of international law that no one can impose on states obligations that they haven't consented to themselves. So the supply of weapons would be against the specific wish of the states. parties to the convention. And this was very specifically explained during the travel that was done when this convention was adopted. And France proposed the initial text that appears on the screen when talking about the fund. They said funds mean any type of financial resource, including the cash or currency of any state, bank credits, travelers' checks, bank checks, money orders, shares, securities, bonds, drafts, letters of credit, and any other negotiable instrument in any form, including electronic or digital form. Other states have manifested the same understanding of the term during the travel. Just to mention one, Japan. Japan said funds means any form of pecuniary benefit. The desire of states to limit this word to terrorist funding is implicit in the implementation of the convention. The Criminal Court of the Netherlands said in Article 4021, which is on the screen, a person who deliberately provides himself
or another with means or information, or deliberately collects, acquires, possesses, or provides another with objects which wholly or partly, directly or indirectly, serve to offer financial support for commission of a terrorist crime. Nul besoin.
There is no need to underscore that the object can be movable or immovable, tangible or intangible. But it will only finance terrorism if it actually serves to offer financial support for the commission of a terrorist crime, according to Dutch law. The word fund should not be understood in an abstract, vacuous manner. It is part of a whole. It is a fragment of the text, which is the Convention of 1999. In order to understand it, other provisions of this treaty must be considered because all of them are articulations of the same obligation. And in this respect, the preamble is very important because the object of the convention is expressly mentioned. The aim is to suppress specifically funding of terrorist activities rather than, in general, suppressing all support provided to terrorist activities. Paragraph 7 and paragraphs 10 to 13 of the preamble, plus the different articles of the Convention, including Articles 8, 12.2, Article 13 and Article 18 of the Convention, all these articles refer to financial support provided to terrorism. The ICSFT specifically aims to dry up financial support provided to terrorist organizations, and this is confirmed by the fact that Resolution 1373 of the UN Security Council, based on Chapter 7 of the Charter, almost completely contains essential elements of the regime constituted by the 1999 Convention and makes the distinction between terrorist financing and weapons provision. And they figure in two different paragraphs. The same applies to Resolution 51/2010 of the General Assembly, which is in paragraph 7 of the preamble of the Convention. Many states have followed the same approach, including Ukraine, for whom weapons and terrorist financing are treated in two different articles and separate articles in the Ukrainian Criminal Code. Article 258.4 says the following, as you can see on the screen, concerning weaponing weapons, and Article 258.5 concerns financing of terrorism. And these definitions use first article of ICSFT, and this is hardly surprising for anyone. Madam President, ladies and gentlemen, members of the court, this brings me to the end of my presentation, and I would urge you to call Professor Sienho to the podium. Thank you very much.
I thank Professor Azari, and I now give the floor to Professor Sienho Yi. You have the floor, Professor.
Madam President, distinguished members and judges of the court, it is a distinct privilege for me to appear before you today to participate in the peaceful settlement dispute before this august institution, and to do so on behalf of the Russian Federation. My task is to clarify Russia's position on the interplay between ICSFT and international humanitarian law, IHL. It is indisputable and accepted by both parties that there existed an armed conflict in the Donbass during the relevant period for purposes of this case, that the existence of this armed conflict triggered the application of IHL is likewise indisputable. This, in turn, has significant implications for the present case, for the interpretation and application of the ICSFT and the conventions referred to therein, contrary to what Ukraine argues. Ukraine painted a picture of ICSFT and IHL as separate and unconnected, or in its own words, distinct bodies of international law. On Tuesday, Counsel for Ukraine argued essentially that there is no conflict between the two bodies, because only ICSFT addresses financing of terrorism. And for this reason, if a lex specialis has to be found to be applied, it is ICSFT, and it is also the lex posterior. With respect, the Council is wrong. First, the ICSFT and IHL do not both deal with financing. They do both deal with defining terror. Second, the relationship between the two bodies of law is not subject to a guessing game as the Council played, but has already been specified by Article 21 of ICSFT, which the Council did not even mention once, not even once. Article 21 expressly provides that nothing in this convention shall affect other rights, obligations, and responsibilities of states and individuals under international law. In particular, the purposes of the Charter, international humanitarian law, and other relevant conventions. This article weaves IHL into ICSFT to form an integral applicable law and gives priority to IHL. This relationship between ICSFT and IHL is that depicted in Article 32 of the Vienna Convention on Law of Treaties, VCLT, or the customary rule reflected therein. The provision states that when a treaty specifies that it is subject to or that it is not to be considered as incompatible with an earlier or later treaty, the provisions of that other treaty prevail. The ILC found a number of treaties contain a clause in which parties declare either that the treaty is not incompatible with or that it is not to affect their obligations under another designated treaty. They appear in any case of incompatibility to give preeminence to the other treaty. This led ILC to propose what has become VCLT Article 32. This relationship reaches wider than treaties, as Article 21 of ICSFT uses international humanitarian law to describe what ICSFT is not to affect. This much is confirmed by the travel repertoire of ICSFT. This approach follows closely the nuclear weapons advisory opinion. There, the court decided, in principle, the ICCPR right not arbitrarily to be deprived of one's life applies also in hostilities. The test of what is an arbitrary deprivation of life, however, then falls to be determined by the applicable lex specialis, namely the law applicable in armed conflict, which is designed to regulate the conduct of hostilities. Similarly, the Security Council has repeatedly reaffirmed member states must ensure any measures taken to counter terrorism comply with all their obligations under international law, in particular international humanitarian law. It follows that in a situation of armed conflict, ICSFT clearly does not affect rights, obligations, and responsibilities under IHL. The ICSFT does not, and indeed cannot, criminalize conduct that is lawful under IHL. Thus, the ICRC has declared that instruments aimed at combating terrorism should never define those acts as terrorist that are governed by IHL and not prohibited by it when committed during armed conflict, such as attacks against military objectives or military personnel. Other provisions in the ICSFT and of the other treaties relied upon by Ukraine also confirm this position. Our colleagues have already discussed a few treaties, and which I will not go into now. Our reading is further confirmed by Article 2, Paragraph 1b of ICSFT, which defines offenses to include any other act intended to cause death or serious bodily injury to a civilian or to any other person not taking an active part in the hostilities in a situation of armed conflict, when the purpose of such act by its nature or context is to intimidate a population or to compel a government or an international organization to do or to abstain from doing any act. During the treaty negotiations, concern was expressed that a broad definition of the protected persons will involve difficulties with application of humanitarian law and could lead to the situation where certain acts would be classified as terrorism when they would be acceptable under humanitarian law. To alleviate such concern, as the counter memorial points out, the interpretation of ICSFT, including the interpretation of mental elements of a terrorist act under Article 2(1)b, must take place in light and against the background of simultaneously applicable and closely related relevant standards of international law. Article 51(2) of Additional Protocol 1 of 1977, dealing with international armed conflict, must also be taken into account. That provision provides that the civilian population as such, as well as individual civilians, shall not be the object of attack, acts, or threats of violence, the primary purpose of which is to spread terror among the civilian population are prohibited. The exact same language is also found in Article 13(2) of the Additional Protocol 2, which is shown to you on the screen, which I will not read. Of great importance, this form of intent was emphasized during the treaty negotiations. The ICRC commentary on Article 13(2) states, any attack is likely to intimidate the civilian population. The attacks or threats concerned here are those, the primary purpose of which is to spread terror, as one delegate stated during the debate at the conference. This rule is considered to reflect customary international law according to an ICRC study. Thus, the definition of Article 2(1)b of ICSFT should be read in conformity with the criteria for the war crime of terror under IHL. In a situation of armed conflict, only acts which have spreading terror as their primary purpose may fall under Article 2(1)b of ICSFT, and this firmly excludes incidental or collateral damage to civilians. In fact, these were also the position that Ukraine itself expressed during the negotiations leading to the adoption of the additional protocols. Ukraine does not object to these positions of its own, of course, or the Russian Federation description of them in the counter memorial. The above reading of Article 21 of ICSFT and relevant provisions is supported by the views of the ICRC commentary, the UNODC, and many scholars expressed in a variety of contexts or in the judges' folders for your references. Downplaying the role of IHL, as Ukraine attempts to do, will effectively criminalize war fighting by non-state armed groups as terrorism. To borrow UNODC's phrasing, this would disincentivize non-state actors from complying with IHL. Since the act being financed should not be considered terrorism in the first place, this will undermine the object and purpose of ICSFT, effectively rewriting it to become a convention on the suppression of general financing of non-state groups. In light of the above analysis, IHL is not irrelevant to the interpretation or application of the ICSFT. Article 1 weaves IHL into the convention to form an integral applicable law and gives priority to IHL. In a situation of armed conflict, only acts which have spreading terror as their primary purpose may fall under Article 2(1)(b) of the ICSFT, and this clearly excludes incidental or collateral damage to civilians. I believe this is an auspicious time for us to take a coffee break if the court so wishes. I thank you, Madam President.
I thank Professor Guy, and indeed, before I invite the next speaker to take the floor, the court will observe a coffee break of 10 minutes. The sitting is suspended.
Consider what that means. It means that whilst the DSB produced a glossy report, which is ostensibly convincing for a layperson, that triangulation was fiction. And this is key analysis relied on supposedly to prove that a Russian missile exploded outside the cockpit. Secondly, slide 8, bow ties. In order for the DSB and indeed Ukraine to implicate Russia, they have to show that it was a missile with a 9N314M warhead, because that's the kind of missile in use by Russia that contains bow ties. And here you see the bow ties. They're vertical, and between them are smaller square elements. Now, the point is, only this missile could be the Russian one. An older missile without bow ties may well have come from Ukraine, and you've seen the point that on the Dutch military intelligence document, it was a Ukrainian buck that was closest to MH17. Now, the DSB made use of purported bow ties, but let's look at their provenance. The story begins with Mr. Ackermans, a journalist at RTL. After bow ties became an issue in the DSB investigation, Mr. Ackermans claimed to have found one. RTL produced a video of the find. We've got it at slides 11 and 12. Here is Mr. Ackermans. Next slide. There is the bow tie lying on top of wreckage of MH17, very conveniently. But, see slide 13, that piece of wreckage landed the other way up. So that bow tie could not possibly have been discovered sitting on the other side of that piece of wreckage. Now, before this upside-down problem was discovered, the DSB used the Ackermans bow tie to persuade Almaz Antey, the Russian manufacturer of the missile, that it must have been an N314M with bow ties. And Mr. Malashevsky, a specialist there, made a presentation that cited the Ackermans bow tie front and center. You've got it on slide 14. Almaz, maybe naively, took for granted what was said about provenance of physical evidence. And you've got Mr. Malashevsky's witness statement in the rejoinder at Annex 369. Now, when the DSB encountered the upside-down problem, they quietly stopped relying on this bow tie. But there is no hint of any investigation by the DSB, the Dutch police, the JIT, or anybody else into how and why that false bow tie was sought to be inserted into the DSB's work. Any proper investigation would have worried immediately that somebody had the animus of trying to blame Russia. There was no such concern at the DSB. Instead, it began to discover its own bow ties. In around July 2015, the DSB claimed to have found them in the bodies of the crew of the aircraft and in the cockpit, slide 15. But Russia pointed out two problems. First, the bow ties were supposedly found long after the funerals of the crew. We've given references to coverage of those. Ukraine has not answered this point. There is nothing from the DSB. The argument would have to be that bow ties were found earlier and only examined later. But given the total focus on missiles, proof of a Russian missile, and anything significant, it is absurd to suggest that items, fragments that didn't look like parts of the aeroplane would be left for later. It doesn't help that between the draft DSB report and the final report, the DSB was thoroughly confused about where the bow ties came from. The fragments are attributed to different bodies. We have another bow tie fragment supposedly discovered in the cockpit, but different locations were given for it. You see on that the witness statement of Mr. Malashevsky and a schedule from Almaz. Now, there was a further problem with this cockpit fragment. We have that at slide 18. Scientific analysis showed that after the explosion of the warhead, the heavy bow ties would lose mass, but there was a certain minimum mass. And the Netherlands National Aerospace Laboratory calculated that. It was 5.67 grams. The NLR weighed this very piece and discovered that it was 5.5 grams, and so the conclusion followed that it did not qualify as a potential bow tie. The DSB ignored that. It proceeded to make this bow tie its star bow tie, even though the mass was inadequate. And the solution to the mass problem was extraordinary. This same fragment was falsely recorded in the final DSB report as having a greater mass. 5.5 grams, measured by the National Aerospace Laboratory, became 6.1 grams, a little over that laboratory's minimum. There has been no explanation whatsoever as to why the DSB falsely recorded this key piece of evidence. Next, problems with penetration damage. The DSB relied on penetration damage to the port side of the cockpit. You see that overall there, and you see lots of pieces of the port side fuselage at the cockpit. But where did these pieces come from? Mr. Bukurcu, an OSCE observer, was very concerned about what happened to the cockpit on the ground. We see that from slide 23. We've set out what he said. In summary, he said, at first the cockpit was very much intact, then it was spread out, and men with uniforms were hacking at it with power saws. See now slide 24. This shows that the men with power saws were members of Ukraine's special emergency services, state emergency services, I'm sorry, the SES. See also slide 25. This shows that by the time the cockpit wreckage was taken away, all of the port side of the cockpit was missing. Note some chronology on that. See slide 26. The last physical evidence was collected between April and May 2015. Now let's see how the DSB recorded the relevant pieces. Slide 27. In the draft DSB report, July 2015, we have one black piece. Now see slide 28. The final DSB report appeared in October 25, and by this stage the black pieces have multiplied. Now it's critical to notice that black in their scheme means no known provenance. So, on the face of it, we have a history of interference with critically important wreckage and no proof of provenance. It's very odd that there is no proof of provenance, given that Mr. Bukurcu, the OSCE observer, said that the cockpit was initially intact before mysterious men hacked at it with power tools. Those men from Ukraine's emergency services. But at any rate, this is evidence without provenance, which has been interfered with by Ukraine, and it's not proper evidence in this case. This point has been live for a long time. It's never been dealt with by Ukraine. They just put forward the DSB report as if that is dogma on everything. There was another problem. Almaz-Antey did an experiment where they replicated a Buck M1 explosion with the bowtie warhead next to a similar aeroplane, slide 30. Here, with a bowtie warhead in the position claimed by the DSB, we see a rash of bowtie holes. There were no bowtie holes on these mysterious pieces said to represent the port side of the cockpit in the DSB report. Almaz-Ante concluded that the missile could not have been a modern missile with a bow tie warhead, given the absence of bow tie holes. If there were a missile, it would need to be an older one from Soviet times, which only had the small square shrapnel and not the larger bow ties. See on that Russia's Rejoinder, Annex 1, page 128. Now that suggests a Ukrainian missile. And this affects other key points, because shrapnel damage can give an indication of the orientation of the missile relative to the aircraft when it explodes. And that allows calculation of the area where the missile was launched from. And the latest work from Almaz shows that the DSB's assessment of the firing position does not work. See slide 31 and the evidence referred to there. Next problem, explosive traces. The DSB claimed to have done swab tests for explosives, but the draft report says that 500 swab tests were done on pieces of aeroplane wreckage and also on missile pieces. In parenthesis, the missile pieces emerged with no provenance at all very late in the day. In the final report, that 500 becomes 126, with no explanation. And it makes no sense, because please imagine you are doing a proper scientific forensic investigation looking into an incident like this. How can you possibly lose that many swabs? In the conclusions of the final DSB report, it was said at page 255 that the missile parts had traces of a type of explosive, RDX, that is similar to the traces found on the wreckage of the aeroplane. But even within the DSB report, just looking at that, it's not correct. The DSB draft report in July 2015 said at paragraph 2.16.3, 500 swabs were taken, positive results were recorded on the wreckage of the airplane for RDX and TNT. The final report said 126 swab samples, and it said that positive results were recorded for RDX, TNT and PETN on the aeroplane parts, whereas only RDX was found on the missile part. So that's all very odd. First, there was reluctance between the two reports to mention PETN, and we don't know how extensive those swab results for PETN were. We do know it's not a mistake, because in the Dutch prosecutor's prosecution, he presented one page of the swab results, and it shows that the aeroplane parts bore traces of PETN and its degradation products. And you've got that page of results at slide 35, PETN, you see up at the top. The significance is this. PETN is not RDX. It's the terrorist explosive of choice when it comes to blowing up airliners. It was used by Richard Reed, the shoe bomber, and Umar Farouk Abdul Muttalab, the underwear bomber. There has been no explanation why the DSB has been inconsistent about the number of swab tests for explosives. There's no explanation why it did not mention PETN in the draft report, and there is no discussion of the potential significance of PETN. In practical effect, the DSB only explored a case against Russia, and that case was based on non-existent bow ties and wreckage without provenance. The second part of Ukraine's case against Russia relies on the alleged tracking of a buck TILA from Russia and back again using social media. Ukraine relies on a Dutch national police report, Bellingcat, a supposed collective of citizen journalists, and the work of the Joint Investigation Team, the JIT, and Russia was not a member of that. Again, Russia has not agreed to delegate fact-finding to any of those. Now, these digital files were supposedly found on the internet or provided by Ukraine's security service, the SBU, but there's no proper evidence of provenance or authenticity. And the pictures supposedly show the buck unit at various points on the route. We can see that from the Dutch National Police report and the pictures showing it stopped at various points. All of these are digital media files, and that digital media is malleable. Russia has asked for the original files for years now. They have not been produced by either the Ukraine or the Netherlands. And it's not just Russia that thought they were important. Please look at slides 41 to 44. 41 is a document from the Australian Federal Police Forensic Department. They wanted the original files to do their own analysis. And you can see their conclusion at slide 45. This is in 2015. Australia is a member of the JIT, and the Australian Federal Police are not provided with original files. What they were provided with was clearly manipulated. Next, the Snizny video. One of the most disturbing parts of Ukraine's evidence concerns the Snizny video, showing a buck unit that supposedly moves up a hill or towards a hill near Snizny to its firing position, and it's said that it shot down MH17 from there. Again, Ukraine has provided no original data file, and the provenance is very strange. Elliot Higgins is supposed to have found it on a social media account. He founded Bellingcat about 3 days before MH17 was destroyed. Mr. Higgins has said that he found the video on YouTube on the 17th of July, the day of destruction of the aeroplane, but the original posting was taken down. No matter, says Mr. Higgins, he had taken a copy of it, and he says that he re-uploaded it onto YouTube the same day. Fortunately for justice, the versions first uploaded was preserved on an automated web service, and Russia's experts were able to study it, and their report is Rejoinder Annex 362. Now comes an extraordinary revelation. The first version of the Snizny video was encoded on the 16th of July 2014, the day before MH17 was destroyed. And you have that at slides 47 to 8. That is significant because, as we see slide 49, the date of uploading onto YouTube gives the encoding date, even if the video is only published and released for public view later. And hence, one can have the date of 17 on the published version when you look at YouTube, but when you see the metadata of the original file, the encoding was on the 16th. This absolutely shows that the video existed before MH17 was destroyed, and it absolutely shows that it cannot prove a Russian buck moving to an alleged firing position. Quite separately, there are lots of problems with the video. I'm going to take those very shortly because time is short. But there's a hard line at the top of the video. Sorry, first of all, on this slide 50, one of the bushes, vegetation, develops a hard vertical line as the buck goes by, maybe indicating the edge of a superimposed layer of activity where the buck moves. And then slides 51, 52, there's a hard line across the video just before the hill, and the buck stops precisely there. In fact, the buck stops with the propagandists who developed this kind of thing. We'll come to that later. But the buck stops there, and the reason is that the forger did not have a view of the buck giving its top side in order to take it up the hill. There are also lots of technical issues, problems with the video listed at slide 53. Please read that. Note that later versions of this video were better in quality than the first, better than the original. That does not happen with genuine evidence. Now, evidently the JIT was happy to rely on this video, which has all the hallmarks of an information operation. The JIT said there were checks on everything digital, but obviously there were none. Otherwise, all of these points would have been seen and openly and fairly addressed. As to provenance, the JIT at best had a secondary copy put up by Mr. Higgins, but that doesn't authenticate the original video. And more generally, it was wrong for the JIT to accept anything from Mr. Higgins or Bellingcat without answers to some very obvious questions. For example, who exactly is Mr. Higgins? Does he have any relevant expertise? How did he, in his personal career, suddenly move from unemployment to expert blogger on chemical weapons in the Syria conflict? Then come some really serious questions. Why was Bellingcat listed as a partner organisation in the Integrity Initiative? See slide 55. The Integrity Initiative seems to be a platform for information operations that was secretly funded by the British government. You see that on slide 56 and slide 57. The funding went through the Institute for Statecraft, which is an opaque Scottish charity. It's difficult to find who's behind it. And its registered office, I'll show you that at slide 58, was a derelict factory in Scotland. The Institute for Statecraft was run by one Christopher Donnelly. Slides 59 and 60, you see his career. Mr. Donnelly, on the face of it, was Special Advisor for Central and Eastern European Affairs for 4 NATO Secretary Generals. Bellingcat was also involved in other proposals for information projects, like the Zinc Consortium at slide 61. You see Bellingcat bottom left, next to media diversity, then the Digital Forensics Lab, which is Atlantic Council, and that is adjacent to the rump of the bull. Now, another person involved in this Zinc project was Gordon Macmillan. We have his CV also. He was an executive of Twitter, but he was also a reservist in the British Army's 77 Brigade. See that at slides 62 to 63. The 77 Brigade is the British Army propaganda unit. Slide 64. Now, any proper investigation looking at matters objectively might have been sceptical about the provenance of that video, and they might have looked at points like that. Not any of the august institutions on which Ukraine relies as evidence, without providing any of the underlying digital material. Finally, let's look quickly at intercepts. These supposedly show rebels calling for air support, the sending of a Russian Buk-Tilar and crew, and surprise when it was realized that a civil plane had been hit. The first and most important intercepts were published by the SBU on the 17th of August 2014, but you see slide 66. Again, this compendium was encoded the day before MH17 was shot down, on the 16th. Bellingcat admit that, but they try to say, oh, there was a technical hitch with all MP4 files because of a problem with the standard used to encode them. Russia's experts, who again are very expert indeed, have rejected that for a list of technical reasons which you have in Russia's rejoinder at Annex 362. But there's a more prosaic point. This would have led to wrong dates on millions of MP4s for years and years and years all around the world. That is absurd, and nowhere has Ukraine sought to prove Bellingcat's technical hitch. Again, this is a point that has been out there. Bellingcat is content to address it in some internet article, but Ukraine doesn't present that as evidence, because had it done so, it need only be presented to be seen as ridiculous. A further point. One of the conversations was clearly manipulated by Ukraine's security service, the SBU, see slide 67. It was manufactured from an earlier intercept. The call involved Mr. Besler, and the conversation, the earlier conversation, much before MH17, was about the shooting down of a Sukhoi aeroplane. The SBU removed the reference to Sukhoi and presented this as relating to the shooting down of MH17. Now, Mr. Besler sued Bellingcat in Russia for implicating him in the destruction of MH17. Madam President, distinguished members of the Court, you would be forgiven for not noticing that, because curiously it's not something that's as featured in the Western press. Bellingcat was fully represented in those proceedings in Russia. It chose not to offer any defence, and damages were awarded. And in Strasbourg, Russia also presented forensic expert evidence from a Malaysian expert, Mr. Rosen, who showed all kinds of indications of manipulation, slide 69. None of that has been addressed. Now, all of this is problematic when one takes into account also the radar evidence, slide 71. If a buck had been launched near Snizhny, it would have been seen in profile on 3 sweeps of the Ust-Donetsk radar. According to Almaz-Anti, that means there's a 99% probability that it would have been seen. It follows there's a 99% probability that no buck was launched near Snizhny. Now, I'm not going to go through it again, but that was the conclusion if you look at the end of the English translation of the Dutch military intelligence document. There were no bucks in range. Now, I have pointed out what are obvious defects in the way that Ukraine has sought to prove its case. You cannot attempt to prove a criminal case without showing provenance of the evidence, and that goes for physical evidence. You cannot purport to prove it a digital case without providing the digital files. That should be an end of it. But of course, some people say, when points like this emerge, oh, come on, surely there could not be a conspiracy as big as this. But actually there could. At slides 85 to 87, you've got some top secret documents from the Five Eyes military alliance. They were released by Edward Snowden and featured in the press. And the biggest Snowden revelation was not that the Five Eyes countries listened to everybody's phones. It was the way they create fake material on social media, and you see the relevant social media identified: Twitter, YouTube, Facebook, Flickr. Then, next slide, they take it up from social media via blogging into the mainstream news. You recall that Mr. Higgins emerged as a famous blogger on the Syria conflict, and he has mediated much of the material, including the Snizhny video, from totally unknown source into what he would like to present as the accepted narrative on MH17. Next slide, you see the purposes of all of this. Again, in Five Eyes training documents, and you see they include a false flag operation. Now, in our written submissions, which I respectfully urge you to read, we drew attention to these documents in the Georgia v. Russia case, where it was said that Russia launched an Iskander missile at the town square in Georgia, in Gori. And an expert British colonel was called. It was put to him that that case relied entirely on videos that were defective and bits of alleged shrapnel, and it was put to him that this could be a digital confection. He said, "It is a contemporary flaw, in my view, of what happens. Yes, it's also used to great effect, I might say." Now, the short point for today is Ukraine has not proved its case. But the deeper point is no tribunal has looked at these matters. The DSB, JIT, police in the Netherlands have not done so. It would be entirely wrong to allow this situation to be used to great effect by Ukraine. Madam President, those are my submissions. I hand over to Mr. Udovichenko, who will deal with some other terrorist alleged attacks.
I thank Mr. Swanston, and I now invite Mr. Kirill Udovichenko to address the court. You have the floor.
Madam President, distinguished members of the court, it is an honor for me to appear before you on behalf of the Russian Federation. My task today is to address the substance of Ukraine's claims concerning shelling, bombing, and killing incidents. As tragic as some of these events are, there is no way to find that these are acts of terrorism, the funding of which would be prohibited by ICSFT. Rather, they are unfortunate episodes of an armed conflict and concurrent civil strife in Ukraine. As I shall explain, Ukraine's failure to properly contextualize the incidents in question is fatal for its claims. Let us first deal with the shelling incidents. Ukraine raises 4 isolated episodes that took place in Donbass over a period of 3 years, between 2015 and 2017, near Volnovakha, Mariupol, Kramatorsk, and Avdiivka. These places were among many towns affected by military conflict in eastern Ukraine. Mr. Kuzmin explained earlier today that this conflict emerged when Ukraine started heavy military operation known as the ATO against the people of Donbass. Yet on Tuesday, Ukraine pursued a well-known media strategy of labeling its military adversaries as terrorists and suggested that their ultimate goal is spreading terror against civilians. This Ukrainian narrative can only succeed with those unfamiliar with the inherent horror of any armed conflict. We invite the court to look into the incidents beyond the narrow black and white concepts advanced by Ukraine. The acts in question did not constitute acts of terrorism within the meaning of Article 2.1b of the ICSFT for the following reasons. First, the persons involved targeted Ukrainian military objects. Second, there is no proof that there was an intent to cause damage to civilians. Third, the civilian casualties that occurred were largely caused by Ukraine's own conduct. Fourth, the evidence showed that the republics attempted to minimize collateral damage during the armed conflict. And finally, Ukraine's case is built on unreliable evidence. Let us first look into what their targets of the shelling were. Although there is no compelling evidence that the attacks were actually carried out by the republics, in each case, the shelling did aim specifically at military target. In Volnovakha, the attack targeted a roadblock. 2 days ago, Ukraine repeatedly called it a civic checkpoint. Well, let us have a look at it. Would you call that a civilian object? Certainly not. The roadblock had armed personnel, armored vehicles, fortifications, firing positions, and a large net of trenches. Well, in fact, Ukraine's own official called this roadblock a military installation. And Ukraine's own legislation considers such roadblocks to be military objects that have both defensive and offensive functions. The personnel deployed at the roadblock was from Kiev 2 Battalion of Ukrainian Armed Forces. Ukraine has called this battalion quote, police patrol unit that assisted the border guard. But it is difficult to see how soldiers armed with heavy machine guns, grenade launchers, and heavy armored vehicles could be associated with a police force. They are not. In fact, as demonstrated by General Samolenkov, Kiev too played a crucial role in Ukrainian armed forces' offense against the town of Dokuchaevsk. Ukraine puts much emphasis on that a civil bus has been hit during the attack. But the vehicle was inside the roadblock when the shells hit the territory of the installation. General Samolenkov's expert witness shows that the bus would therefore have been an inevitable collateral in case of any assault against the military facility. In Mariupol, the attacks aimed at Ukraine's defensive positions, a set of trenches and military checkpoints on the city border. Clearly, a military fortification. Even Ukrainian authorities unanimously confirmed that the shelling targeted military objects. In Kramatorsk, as Ukraine's own expert agreed, the attack was aimed against the RTUK command headquarters and military vehicles at Kramatorsk airfield. The attack destroyed multiple Air Force units, MLRS launchers, and ammunition silos. In Avdiivka, Ukraine again agrees that the attacks hit legitimate targets, such as Ukrainian armed forces combat positions, artillery fire positions, supply routes, places for allocation troops and armored vehicles. Remarkably, the Ukrainian forces chose to station those right inside the residential areas or behind the residential buildings. In short, all 4 attacks had legitimate military targets. Professor Sien Ho-yi and Mr. Svensson have explained that in the context of an armed conflict, it is the rules of IHL that govern the conduct of combatants. The ICSFT does not, and indeed cannot, criminalize conduct that is lawful under the IHL. I then turn to my second and closely connected point. The lack of intent to cause death or serious body injury to a civilian within the meaning of Article 2.1b of the ICSFT. Since it cannot prove a specific terrorist intent, Ukraine had to come up with a creative but untenable theory. It argues that indiscriminate weapons used in the attacks and therefore indirect intent to harm civilians could be inferred from this. First, Mr. Svensson has already explained that Article 2.1b of the ICSFT does not provide for indirect intent. Well, this should be the end of the matter. Second, the weapons that were used in the shelling incidents, MLRS BM-21 Grad and BM-30 Smerch, are not prohibited or inherently indiscriminate. They are widely used in hostilities around the world. Ukraine's own expert states that Smerch cluster munitions vote, and I quote, an ideal weapon for the attack at the Kramatorsk airfield. There are numerous reports that Ukraine used Grad, Smerch, and other artillery to shell residential areas in Donbass. In fact, just 9 days after the shelling hit the bus in Volnovakha, a similar bus in Donetsk was hit by Ukrainian forces, killing 8 civilians and injuring 13. The Human Rights Watch report documented multiple use of Grad, as well as heavy MLRS systems with cluster munitions, by Ukraine to shell populated areas of the republics, including Starobeshevo, Makiivka, Ivovaisk, and Novosvetlovka. In fact, the OSCE report that during 2014 to 2017, many more civilians were killed or injured on the territory controlled by the republics than at the territory controlled by Ukraine. In other words, shelling by Ukraine forces caused many more civilian casualties than any alleged shelling by their adversaries. If one assumes, as Ukraine suggests, that indiscriminate shelling can somehow qualify as an act of terrorism, it necessarily follows that Ukraine itself engaged in such terrorism and did so on a massive scale, being the prime terrorist in the conflict. Ukraine provided what they call intercepts of communications between the Republic fighters. There is no evidence that these intercepts were genuine or complete. However, even these records evidence that precautions were taken to avoid loss or injury of civilians resulting from the attacks. The DPR closed civilian traffic near Berezhno and Volnovakha, including on the day of the roadblock was attacked. If it were the DPR who attacked the roadblock and the intent was to harm civilians, why would they want to limit civilian traffic? In Mariupol, raging shots and local observers were used to divert fire away from residential areas. There is absolutely nothing in the intercepts that show that the attacker ever intended to hit civilians or were indifferent to that. On the contrary, the intercepts related to the Mariupol shelling show that the attackers were shocked by unexpected hits on a civilian-populated area. My third point is that civilian casualties resulted from Ukraine's forces' own impermissible defensive strategy. Kiev hid its military units inside or close to civil objects, used civilian vehicles to transport troops, and refrained from evacuating civilians from the surrounded areas. This tactic was effective. Ukraine waged war on Republic's territory and had high tolerance for collateral damage, while the opposing side could not risk hitting their family members, friends, or neighbors who got separated by the front line. Ukraine knew how to properly utilize this. In Volnovakha, Ukrainian forces arranged a civil checkpoint at the same place as its military checkpoint. Ukrainian forces deliberately conducted lone searches to create waiting lines at this roadblock checkpoint. Those wishing to pass had to undergo extreme danger by having to loiter around a military target in the center of a large minefield. An explicit disregard for civilian safety inevitably led to tragic loss of innocent lives. In Mariupol, the Ukrainian forces dug their trenches and arranged defensive positions very close to the densely populated residential district called Vostochny. Despite the obvious threats to the residents, they were not evacuated or placed in shelter. In Kramatorsk, although the size of the airfield allowed otherwise, the troops and tanks were stationed as close as possible to the bordering residential area. This was again an improper intent to make NATO personnel a collateral risky target. In Avdiivka, the Ukrainian forces hid their armor behind populated residential buildings, literally at their backyard. Even though the front line passed across the city and heavy battle was waged inside its suburbs, the residents were not evacuated. Thus, we repeatedly observe a clear pattern of Ukrainian human shield tactic. My final point would be that Ukraine's case rests on totally unreliable evidence. There is absolutely no sense in what Ukraine defines as the purpose of the shelling incidents. The Minsk peaceful process could unlikely be affected by an individual case of shelling, as it occurred against the background of a bloody, full-scale armed conflict. You can see that only in the year 2014, Ukraine executed numerous attacks against civilians opposing the Maidan government in Donbass and Ukraine. Besides, Avdiivka incident happened long after the Minsk agreements were concluded. It is indicative that, according to Ukraine, it has been provoked by a US administration entering office, something that literally happened on the other side of the world. But the flaws of Ukraine's position transpire in smaller matters as well. 2 days ago, Ukraine relied on an intercept which allegedly proves that DPR commander cheered about the shelling of Vostochny district in Mariupol. However, this reaction does not have anything to do with the shelling of the city. The word Vostochny here refers not to Vostochny residential area, but to the Vostochny checkpoint, a military target which is 1.55 kilometers away from the residential district. Both the military checkpoint and the residential area are referred to as Vostochny. Another intercept, the one that Ukraine presents as its central evidence, was supposed to show that the republics intended to terrify population. This one, well, it is just a text document typed in Microsoft Word with no audio provided. Well, let alone, given the context, the speaker clearly intends to terrify opposing military personnel, not civilians. He explicitly demonstrates compassion for the latter in the last sentence. Further, the evidence provided by Ukraine suggests that at least some of the incidents were actually friendly fire. Ukraine's satellite imagery experts failed to establish any precise location whatsoever of the rocket launchers. Instead, they suggested various potential firing positions. None of them stood the challenge of basic analysis of a competing expert report. We can see that Ukraine's experts rely on a few scorched landmarks or tire trails for their calculation. However, these were captured on satellite images made long before the day of the attack, or do not appear in these images until several days after the shelling. The tire tracks that Ukraine attributes to January 15 were already there in November 2014. And on the following slide, it is relevant to the shelling that occurred on February 10, 2015. Ukraine points us to the photo on the right. It was made 17 days after the incident. However, no such tracks could be found on the photo made on 12 February 15, 2 days after the shelling. For obvious reasons, Ukraine experts choose to ignore such clear mistakes. Without this manipulation, Ukraine's case makes no sense. With it, Ukraine's case is simply a lie. The Volnovakha roadblock was at least 15 kilometers away from Republic-controlled territory. Ukraine's own evidence showcasts that it was hit by Grad rockets with spoiler rings. This allowed General Samolenkov to determine that the firing position was located approximately 10 to 12 kilometers northeast from the roadblock. Hence, the attack could not be carried out from the area controlled by the republics. Perhaps this is the matter of a friendly fire from Ukraine's own artillery. Ukraine's expert tried to rebut this by stating that there was no spoiler rings at the rockets. Without the rings, the Grad rockets would reach up to 19 kilometers. Some Republic forces might have indeed been in that area. But Ukraine caught in its own net. It concurrently submitted expert evidence showing that the rockets hitting the roadblock were in fact had spoiler rings limited the range of impact. Hence, friendly fire stands as the only plausible option. To bring charges to deliberately targeting civilian objects, Ukraine presents the strikes on the Kramatorsk airfield and the impacts on residential area of Kramatorsk as two different attacks. But Ukraine concealed all possible data on the damage done to the airfield. Otherwise, this data would have undoubtedly confirmed that the airfield and the residential area suffered damage at the same time and in course of a single shelling. The arguments of Ukraine on shelling incidents fail to make a solid and credible case. As a result, none of the shelling incidents were acts of terrorism within the meaning of Article 2.1b of the ICSFT. Madam President, members of the Court, may I please delay lunch for another 10 to 15 minutes to cover bombing and killing incidents?
You may. Please go ahead.
Thank you very much. I now move to the alleged bombing and killing incidents that Ukraine raises in this case. We will look at each incident in turn, but before we do that, two general comments are necessary. First, same as with the shelling incidents, Ukraine wants you to ignore the context in which these events may have taken place. That context again negates allegations of terrorism. The 2014 coup d'etat in Kiev led not only to the armed conflict in Donbass, it also provoked civil strife and unrest elsewhere throughout Ukraine. Two political groups clashed: the Maidan supporters, who were mostly Ukrainian nationalists and radicals, and the Maidan opponents, who were mostly activists from Russian-speaking regions. The Maidan supporters were quick to escalate violence. They bombed, burned houses, and killed many anti-Maidan leaders. Most infamously, they burned down the House of Labor Union in Odessa and killed opposing activists who hid there. The breakout of violence was marked with radicals storming governmental buildings across the country, while weaponizing themselves with firearms captured from police offices and military warehouses. Almost simultaneously, former Member of Parliament Oleg Kalashnikov and writer Oles Buzina were murdered in Kiev in April 2015. At the very same time, a Donbass-born writer, Sergei Sukhavuk, was savagely beaten to death. None of these murders were properly investigated by Ukrainian authorities, while the believed perpetrators were condemned and sheltered. It is not surprising that the violence unleashed by the Maidan supporters led to civil violence in return. Ukraine descended to civil strife, whereas various political groups pursued their own interests. However, a civil strife like that cannot itself qualify as terrorism under the ICSFT or ICSTB. Terrorism has a clear purpose: to intimidate population or to compel a government. Otherwise, the Maidan thugs would have been the first to be prosecuted as terrorists, which of course never happened. Remarkably, in its presentation, Ukraine relies on a far smaller number of the alleged incidents than in its previous submissions. For the sake of efficiency, I will address these particular cases while leaving the written submissions to deal with the Romanian allegations. It is highly indicative that Ukraine failed to provide any credible link between the incidents and Russia. In fact, the only thing that actually ties them together is the active involvement of one particular Ukrainian agency, the Security Service of Ukraine, or the SBU. The SBU is notorious for its impermissible methods of law enforcement. The OHCHR, Amnesty International, and Human Rights Watch reported that since 2014, the SBU unlawfully detained, tortured, coerced confessions from political opponents. It also conducted extrajudicial executions and staged provocations. Striving on the narrative of a so-called Russian plot was an easy way for the SBU to extract usual benefits, to expand its authority and importance, to foment anti-Russian hysteria, and to promote certain politicians. The underlying incidents of bombing and killings were skillfully used to serve the purpose of anti-Russian campaign. In fact, they become so notorious that at the end were ultimately brought to the attention of the ICJ. Now it would be revealed that the incidents are no more than mystification, and those which are not lack any connection with Russia and never contained a terroristic intent in their essence. The first incident concerns bombing of Stenapa in Kharkov in 2014. Ukraine says that a Ukrainian Kharkov partisans movement was behind the non-lethal explosion that injured several people in a pub that was used by Ukrainian ultra-right radical groups as a gathering point. After a lengthy investigation, Ukraine is able to put forward only a single piece of evidence: a court decision of the Ukrainian court based on a confession. A confession by Maria Kovtun, a 48-year-old garment worker who was accused of bombing by the SBU. The confession was coerced and given without an attorney present. Her sister gives a graphic example of how it was extracted. I saw her 4 weeks later in the jail through 2 glass panes and 2 bars, and one side of her face was just blue. I can imagine what happened to her then. While still in custody, Kovtun retracted her confession as done under torture and went on numerous hunger strikes. Same pattern applied to all Kharkov partisans who Ukraine tried to paint as terrorists. They all denied their involvement in the bombing. They said that the explosion was staged and was staged on the orders of Ukraine's Interior Minister Avakov. This enabled Mr. Avakov to introduce the anti-terrorist operation regime in Kharkov, curtail human rights, and start in repressions against any suspected dissidents. Given that the bombing was carried out in a small, crowded room, it is especially fortunate that the incident turned out to be non-lethal. Whoever planted the bomb did put a lot of professionalism into avoiding casualties, much more than can be expected from a 48-year-old garment worker. Next incident is the alleged bombing of the Privat Bank office in Kharkov. Here, the evidence that the incident was staged is even more overwhelming. According to Ukraine, some military-trained bomber fired an MRO-A grenade launcher into the bank office. The tube of the weapon, that is the empty shell left over after the grenade has been fired, was allegedly left at the crime scene. A few observations are necessary at this stage. First, this so-called terrorist attack took place at night, when the bank was closed, and there were no people inside or in the vicinity. So even in theory, no death or injury to civilians could have occurred. Lack of terrorist intent on the part of the purported attacker is obvious. Secondly, again, according to Ukraine, the rocket did not even detonate, and in fact has been safely removed afterwards from the bank office by the SBU. Apparently, SBU also safely removed an empty launch tube, as no one has ever seen this, as no one has seen it ever since. However, Russia explosive expert explains that the attack, as it is described by Ukraine, is impossible in principle. An MRO-A rocket almost always detonates when it hits object of attack, or at least when someone attempts to touch it. It cannot be neutralized or removed from the site. Whereas the alleged attacker supposedly had military training, only a rookie unprofessional would fire an MRO-A rocket from a short distance into the second floor of the building. The rocket is not fit for such a close target. It would burst immediately and hurt the attacker. Not a single person was harmed, and property damage was minimum. This surrounding circumstances once again point towards the incident being staged by the SBU. In any event, it entirely lacks the necessary prerequisites to be qualified as an offense under the ICSTB or ICSFT. It also lacks connection to Russia. Ukraine attempts to cure this by arguing that the attack was performed by a uniquely Russian-produced weapon, the MRO-A Borodach grenade launcher. This connection is clearly far-stretched. There is a very similar, almost identical weapon in service with the Ukrainian armed forces, the Shmel grenade launcher. Both weapons operate under the same principles, being in fact developed with the same Soviet technology. There is no physical evidence to suggest that the alleged bombing was made using specifically Borodach and not Shmel. In fact, even the testimony of the alleged perpetrator, as supplied by Ukraine, only mentions Shmel and never Borodach. Ukraine puts a lot of emphasis on the tube of the grenade launcher purportedly found at the scene of the incident, but such tube was never produced. It exists only in the reports of the SBU. Anyway, such shells can be freely obtained in Ukraine as they are no longer dangerous weapons, but simply harmless pieces of metal. It could easily be purchased from different Ukrainian or Russian marketplaces selling military souvenirs, which you can see. Next, it is the bombing at the Unity rally in Kharkov. Ukraine again relies as evidence on coerced confessions of Viktor Titushsky, Sergei Bashlyakov, and Vladimir Dvornikov. However, they all retracted their confessions later as given under torture and without any attorney present. Details of coercion are again graphic. Dvornikov's multiple broken bones, in particular his ribs, as well as bruises, abrasions, and other injuries resulted from the repeated use of physical violence against him. The SBU beat these people and then subjected them to mock executions. It is graceless for Ukraine to employ such evidence in the distinguished court. We are confident that the court would not base its judgment on the confession obtained through torture. Ukraine tries to link various episodes to Russia by arguing that Russian mines were used. Again, this conclusion is far-stretched. These mines are either old Soviet-type mines or mines that are produced outside of Russia, which are in any case in service of the Ukrainian armed forces. The mines could easily be obtained by SBU as well as become available to any ATO veteran. This year, only this year, 2023, the same mine was used in the attempt to assassinate a world-known Donbass writer, Zakhar Prilepin. A pattern of SBU methods is thus consistent. Finally, Ukraine speculates on the death of several farmers in Donetsk region in 2014, including Valery Salo, and paints them, these tragic cases, as part of an alleged intimidation campaign by the DPR against local population. However, neither OHCHR nor any other bodies have ever established that any summary executions took place in that region or that Salo's death was amongst those executions. Indeed, even the otherwise doubtful report of the Human Rights Commission stresses that it is not clear that the motive behind the killing was. It could have been a common crime committed for personal reasons, for extortion, or because of the business conflict. At the same time, Ukraine's law enforcement was unstable. Many radicals were on the loose, and the crime rate was highest in the Donetsk region. For example, in the same period, a Russian photo correspondent, Andrei Stenin, and his two fellow colleagues were burned in a car in the Donetsk region. Thus, what happened to Salo was not uncommon among farmers and private entrepreneurs there. Robberies against farmers, often ending in their murder, have occurred regularly throughout Ukraine in the past and continued to occur. It is regrettable that Ukraine authorities could not protect citizens from crime and violence. But clearly, there is no objective to blame Russia for Ukraine's own failures. No demands were made by the alleged terrorists. No statements or threats were issued. No clear purpose could have been seen through these acts. And finally, no signs of Russia's involvement. The bombing and killing incidents do not meet specific purpose to intimidate a population at large, as requested by Article 2.1b of the ICSFT. They do not rise beyond the level of the ordinary crime to qualify as terrorism. Madam President, members of the Court, it is undisputed that there has been an armed conflict, a civil strife, and a crime break in Ukraine. This led to appalling loss of civilian life. However, none of these tragic events create a plausible case for terrorism or terrorism financing under the ICSFT or ICSTB. My arguments are thus concluded. Thank you.
I thank Mr. Udovichenko, whose statement brings to an end this morning's session. The Court will meet again this afternoon at 3 p.m. to hear the remainder of the first round of oral argument of the Russian Federation. The sitting is adjourned.